Was it Robin? Was it David? That was the question put before the jury in May of 1995, where David Bain stood on trial for the murder of his mother, father, 2 sisters and brother. The jury decided that he was the guilty one, but over the next 12 years, the case would slowly start to unravel. This is the Case Remains podcast, episode 11, part 2, The Unsolved Murders of the Bain Family. David Bain had been imprisoned for a matter of months before the first application to appeal against his conviction was brought before the court. David's lawyers argued that the judge should have allowed Dean Cottle's testimony to be heard by the jury. After all, Lanyette blowing the whistle on an abusive relationship with her father provided more than enough motive for Robin to have killed his family. The appeal, however, was denied. Dean's testimony aside, the court agreed that the Crown prosecution's case was very strong, whereas David's defence hadn't really been plausible. When it came to Dean's evidence, they agreed that it had been clearly inadmissible and that the judge had been right to exclude it. So it seemed as though David really would be spending the next 16 years in prison. After his conviction, David had found an unusual ally in the form of former All Blacks rugby player Joe Karam. The case had caught his attention after he read an article about a group of music students who were trying to raise money for David's appeal. After looking into the case, he came to the conclusion that a severe miscarriage of justice had taken place. He went to visit David in prison and would go on to visit him more than 200 times in the following years. In 1997, he even published a book on the case, the first of 4 that he would eventually write. The first book, David and Goliath, brought even more media attention to the case. In it, he not only championed David's innocence, but even went so far as to accuse the police of planting evidence and lying under oath. The police officers in question would go on to file a defamation claim against Karam, but ultimately it was denied. Nevertheless, an inquiry was launched by the New Zealand Commissioner of Police and the New Zealand Police Complaints Authority following the publication of Karam's book, specifically looking into the police conduct throughout the investigation. The final report of the joint review was published on the 26th of November 1997. The report found that there was no misconduct or inept practice by the police in the investigation of the Bain family murders. All the while, Karam and David's legal team had been spearheading a campaign to get his conviction quashed. After 2 more appeals were denied, they struck gold in 2007 after taking David's case to London's Privy Council. The Privy Council is regarded as the final court of appeal for the Commonwealth of Nations. So despite the crime having taken place in New Zealand, David's case was eligible to be heard by the Privy Council Committee. There, David's legal team put forward a series of arguments that they believed showed a miscarriage of justice had occurred. The first point came in regards to the time the Bain's computer had been turned on the morning of the murders. This was a pivotal piece of evidence, because David had testified that he had returned home at either 6:42 or 6:43. At trial, the jury were told that the computer had been turned on at precisely 6:44 a.m., perfectly timed with David's return from his paper round just 1 or 2 minutes prior. Mr. Martin Cox, a computer advisor employed by the University of Otago, was the person who had inspected the computer at the time of the murders and concluded that its turn-on time was 6:44. But there was a problem. The clock on the computer wasn't set, and Martin Cox wasn't wearing a watch at the time. Instead, he had to rely on the detective's wristwatch in order to record it. It later transpired that the detective's watch was 2 minutes fast, but that Martin hadn't been told about this until he'd already given his evidence at trial. Further evidence was filed by both sides before the appeal, but still neither could agree on a time. They did, however, both agree that it could have been turned on as early as 6:39, 5 minutes before the time initially told to the jury, and between 3 and 4 minutes before David returning home from his paper round. Not only that, but a neighbour had provided evidence that she had seen David on the corner by his house at 6:45 that morning. Though the witness, Denise Laney, had given evidence for the first trial, the time she reported seeing David was presented as being an estimate, as the clock in her car wasn't set to the correct time. A second statement that she had given was never read to the jury, where she clarified that she knew it was exactly 5 minutes past. Nor were the jury told that a police officer had checked the clock and agreed with her timings. Together, these factors cast doubt on the idea that the computer had been turned on a couple of minutes after David returned home. The second issue was the glasses lens found in Stephen's room. The committee had to decide if there was any reasonable possibility that the lens found in Stephen's room could have got there in a time or way that was unrelated to the murders. At the original trial, the jury had been shown a photograph of the scene in Stephen's room, with Stephen's body still there, and Detective Sergeant Weir pointed out the edge of the lens in front of an ice skate near to where Stephen lay. Weir's notes, however, read, "Locate lens from glasses beneath clothing, etc. in front of bunks." When he was cross-examined during the appeal, he conceded that the location he had pointed out at the trial in front of the ice skate had been wrong, although he insisted that he hadn't intentionally misled the jury. He had found the lens under a skate boot under a jacket, but the item he mistakenly identified in the photo must have been something else. He agreed it was unlikely that the skate boot had been pushed to where it was found during the struggle, and that it was possible that the lens had been in the position it was found in before the struggle and hadn't been disturbed at all. No blood, hair, or any kind of human tissue was found on the left lens, or on the lens still in the frames that were found in David's room. Both were also recorded as being dusty. David's bloodied fingerprints on the rifle had also been a damning piece of evidence at the 1995 trial. It turned out, however, that the prints themselves had not been tested, but blood found elsewhere on the weapon had. A fact that neither the judge, jury, nor defence knew about at the time. When tests were carried out on the fingerprint material in 1997, 2 years into David's prison sentence, the results were shocking. There was no evidence of any human DNA. This was a huge bombshell. David's fingerprints in blood on the murder weapon would almost have been enough to convict him on its own. David had said that the last time he had used the gun was in January or February, several months before the murders, and that he had used it for shooting possums. There was a problem, however. The defence expert, Dr. Ari Guerson, was given the same fingerprint sample to test, but for some unknown reason, the sample he received was contaminated, rendering his findings useless. In his conclusion, however, he stated, "In my opinion, based on this scientific data, the only reasonable explanation is that the DNA extracted from the fingerprint on the rifle is not of human origin." Another key element of the 1995 conviction was David's own testimony that he had heard Laniette gurgling as he walked through the house. But again, experts in the case couldn't agree. While some testified that the kind of gurgling noise David described only happened as someone was dying, others stated they could occur up to an hour after death. Another expert testified that they had only heard these kinds of noises when a body was being moved post-mortem. Whichever way you looked at it, it didn't seem the rock-solid evidence of David's guilt that had been presented more than a decade prior. Then there were the bloody sock prints. These had been found throughout the house, and at the first trial, it was accepted that the prints must have been made by David because of their length. A pair of Robin's socks measured 24 centimetres, while David's came out at 27. As a result, the jury were explicitly told that the sock prints were too big to be Robin's. What they didn't know was that Robin's feet had been measured in the mortuary, and they measured at 27 centimetres. During the retrial, Joe Karam measured David's foot for comparison and found it to be 30 centimetres in length. When a forensic scientist asked whether it was possible for David to have made the sock prints, he said that while it was possible, he would expect the sock prints to be larger, and if the prints were only 28 centimetres long, then they were likely to be incomplete. These arguments did cast doubt on David's guilt, but there were only ever two suspects in the murders, David or his father Robin, who had been found dead on the living room floor, a gun wound to his head and the murder weapon lay next to his body. If David didn't do it, what evidence was there to suggest that Robin did? The only motive offered for Robin to commit the murders was a statement from Laniette's friend Dean Cottle that Robin had been raping her. But as we covered, his testimony was never presented to the jury after he was deemed an unreliable witness. It turned out, however, that Dean wasn't the only person Laniette had told about the alleged abuse going on in the home. A Dunedin shopkeeper who lived opposite the Bains described how she had come into his shop distressed and crying on one occasion in 1994. When he asked her what the matter was, she told him that she was on drugs and that she had been raped by her father. Another witness, who ran an escort agency, said that she had hired Laniette and that the young woman had confessed to her that her father had raped her and that it had all started while the family was still over in Papua New Guinea. A fellow student of Laniette and David's also reported having a conversation with her where she told him she wanted to move back to the family home but wasn't sure if she'd be welcome because of a conversation she'd had with her mother. At that time, Laniette had been living in the schoolhouse with her father. Bursting into tears, she said, "I want to move back because I can't live with him anymore. I can't stand what he's doing to me any longer." The conversation had such an effect on the witness that he even made a note for himself. "Must talk to David. What is going on between Laniette and her dad?" But still, none of the evidence at trial pointed to the suicide of Robin Bain. In fact, most of the evidence presented made it sound almost absurd. At the first trial, evidence was given that the range of the weapon to Robin's head wound was about 38 centimetres, not what you would expect from a self-inflicted wound. Not only that, but the prosecution had said at the original trial that it would have been impossible for Robin to reach the trigger from that distance. Now, however, Dr. Robert Chapman, a British forensic pathologist who had also carried out Princess Diana's post-mortem, disagreed. He said he was certain it's a contact or near-contact wound. It also transpired that the prosecution had been using an incorrect measurement of the gun at the 1995 trial, recording it as being 20 centimetres longer than it actually was. But what about the angle of the shot? Robin was right-handed, yet the bullet entered from a diagonal angle on the left side of his head. A series of photographs prepared by British ballistics experts showed a number of positions that Robin could have adopted for a head wound consistent with his. The pathologist, Dr. Dempster, noted, "He's chosen an unusual way of applying the rifle to his head if he's chosen to kill himself with a rifle." There was also the issue of the magazine found next to Robin. It stood on its narrowest edge, which suggested that it had been placed there as opposed to landing naturally. Though it was agreed that it was indeed an unusual placement, there wasn't any evidence either way to suggest that it was either David or Robin who put it there. Ultimately, it was decided that neither the logistics of suicide nor the cartridge on the floor could exclude Robin taking his own life. It was impossible to conclude suicide or homicide either way. If there was any more evidence contained within the house, it was long gone by the time of the Privy Council appeal. The Bain residence had been burned down on July 7th, 1994, just weeks after the Bain family were found dead.
A fiery end for a house that the Bain Family Trust said could no longer be left standing. 5 members of the family were shot dead within its walls. Today, it was destroyed. Fearing someone would set it alight in anger, relatives asked the fire service to do the job properly. Within minutes, the old wooden house was engulfed in flames.
After considering the evidence, the Privy Council released a report on the 10th of May 2007, concluding that a substantial miscarriage of justice had taken place in the trial of David Bain. They stated that there were a number of points of evidence given at the original trial that were presented as conclusive evidence of David's guilt, when in fact there was now a wealth of expert testimony to suggest that they were not. David was released on bail 5 days later, after serving 12 years in prison. His bail conditions included that he not return to Dunedin and that he live with supporter Joe Karam in his house just south of Auckland. But David couldn't rest easy just yet.
The General is releasing his decision on whether David Bain should go on trial again for the murders of 5 members of his family. We cross live now to the Crown Law Office in Wellington.
His guilt or innocence in the light of the new evidence has to be decided by a jury. The Privy Council had the option of allowing Mr. Bain's appeal and causing a verdict of acquittal to be recorded. This is exactly what the Privy Council has done on the 2 previous occasions that it allowed criminal appeals from New Zealand. The third point which I wish to make about the judgment is that the Privy Council ordered a retrial.
Though the evidence for the prosecution was largely the same as that presented more than 10 years earlier, the retrial introduced a number of experts and witness testimony that called into question almost every aspect of the conviction. After a 13-week trial, with evidence provided by 130 witnesses, the jury retired. After less than a day of deliberations, they returned their verdict: not guilty on each count of murder. David walked out of the courtroom a free man, his biggest supporter, Joe Karam, by his side. As well as dedicating 13 years of his life to the case, he had spent millions of his own money during the campaign for David's freedom. Some of those closest to David, however, didn't appear to be convinced of his innocence. His uncle, Michael Bain, as well as his wife and Margaret's sister, were angry that David hadn't defended his family during the trial and said nothing against the allegations of Robin and Lanyette's incestuous relationship. Michael described Robin as a loyal, peaceful and thoughtful man, and no killer. He said that there was no forensic evidence to suggest that it was in fact Robin who had committed the murders, adding, "The family believes the police did a magnificent job. We believe the truth of the matter was presented in the prosecution case." Once he was released, David took action to seek compensation for his time spent in prison. In his affidavit, he detailed the loss of his inheritance and personal property, including a full diving kit, collection of books, clothes, sporting and camping gear, certificates of his academic and sporting achievements, and videos of the shows he had taken part in, as well as recordings of his singing. The inheritance that he lost, aside from the house and land, included collections of pottery, instruments, artworks, and a collection of Australian opals. David said that his imprisonment for the murder of his family had prevented him from pursuing a career as an opera singer. He had been told that he had the potential to be as successful as New Zealand opera singer Jonathan Lamalu, and wrote, "Mr. Lamalu is now engaged 2 years in advance and is singing all over the world. In 1992, my singing teacher told me when I started lessons that I had a wonderful voice and that I could one day create a valuable career for myself." The trauma of his arrest and conviction, however, had taken the joy of music away from him, and he felt that he had lost the major earning years of his life. He also detailed various physical assaults on him by other inmates during his time in prison, including one incident where he had his teeth smashed in, requiring dental surgery. He described alienation by his friends and remaining family members, and the huge toll that prison had taken on his mental health. He had been diagnosed with clinical depression and post-traumatic stress disorder, and had considered suicide on several occasions, saying, "I had no help from the system, and only survived because I was willing to ask for help, and I knew that I was innocent." In 2016, a report by Ian Callanan found Bain was not eligible for compensation because he, quote, "has not established his innocence on the balance of probabilities." He did, however, receive a voluntary payment of $925,000 from the New Zealand government, with the understanding that he would pursue no further legal action against them. After his release, David Bain got married to a primary school teacher, Liz Davis, the daughter of one of his supporters during his second trial. David met one of his groomsmen, Paul Wilson, while they were both in prison for murder. Wilson would go on to kill again and was sentenced to life in prison of March this year. David legally changed his name, and he and his wife have since had 2 children, a boy born in 2014 and a girl who was born in September 2017. Her middle name is Arawa, after David's late sister. The family have since relocated to Australia to start their lives anew. More than 2 decades have now passed since the Bain family were found dead, each life brought to a brutal end in a place they called their home. Though he may have been found not guilty in the eyes of the law, public opinion of David remains divided to this day. As the response to his claim for compensation made clear, a not guilty verdict does not necessarily equal innocence. Thank you for listening to episode 11, part 2 of the Case Remains podcast. If you'd like to keep in touch, you can find us on Instagram and Twitter with the handle @CaseRemains, and you can also visit our website www.caseremains.com, where you'll find write-ups on missing persons cases and unsolved mysteries. Until next time, stay safe.